Hello BEDM 335 students. Welcome to our hopefully last video of the term. Right off the bat I've got to apologize. My throat is growly and my eyes are watering because I have just cut the grass and I am allergic to 7 different types of common grass. And every variety is out there, I'm sure. Anyway, what I'd like to do is go through the exam from last term. And if you have any questions, email me, and then I'll talk about what to expect in this year's exam. So I'm not sure that I even want to waste my time going through the Part A terms because I'm not going to repeat the terms. Simple as that, okay? And secondly, this is something that you could probably do for yourself, but I'll go through very quickly. Limited partnership, the answer was F. Invitation to treat, Q. Gratuitous promise, G. Agency, B. Non-arm's length, J. Due diligence, R. Corporate veil, I. Joint and several liability, H. Seal, A. Boilerplate, S. Force majeure, G. Good standing, M. Vicarious liability, P. Invitation to treat, Q. And dry judgment, O. All right. Last term, we got into question 1 in Part B. Each blank is worth 1 mark unless marked otherwise. Benton Counter's meeting with Will Argue in the law firm offices, and he shows him a document which different term, different topic, but it was a letter of intent, not a contract, okay? Obviously, the document had been executed in counterparts, okay? We were going to enter into a distribution agreement with the Mexican distributor. They are big and have a good reputation. They should really boost our sagging sales. The owner, Senor Valdez, and I have worked out most of the details. Exclusivity, shipping terms, payment by letter of credit, sales quotas, and the like. Then we agreed that we'd have the agreement typed up. And Argue quickly sifted through the document. Looks good. Now let's make it legally binding. What do you mean, says Counter? Do you remember the 6 binding elements of the contract you learned from business law at university? Offer, acceptance, consideration, intention to create legal relations, capacity, and legality, okay? You won't be having something that simple to list this year because it's open book, all right? Correct. You get an A+. So all the elements are present in the distribution agreement except for consideration, because at this point neither of you are receiving any direct consideration. We should get this agreement signed under seal, right? If there's no consideration, a seal makes it binding without consideration. Then he talks about clauses that he would like to include that the lawyers refer to as boilerplate. And then it says list 5 of them. This particular student listed mediation arbitration clause, good. Exclusion of conflict of law is good. Choice of forum clause, good. Choice of law clause, good. And one more required by Mexican law. And he put in exclusion of the CISG. That's not correct. That's another possible, very important boilerplate clause. But the one that's really required by Mexican law is a fair negotiation clause, okay? And of course the courts are too costly and time consuming, so let's insert and this person put in a force majeure clause. Obviously not. This is a med-arb clause, okay? So that means you have to delete med-arb from this side, put it there, and put something else in the top. Well, PPP will be under a legal obligation to supply product to Gdamate. What happens if the plant is destroyed through no fault of your own? I haven't thought of that, says Counter. We should insert that's where you want the force majeure clause, okay, in this pandemic situation. And kudos to my groups that did the law and the business considerations in opening up a business after pandemic. So that was part A on last year's. This year, part B, it's instead of being worth 10 marks, it's going to be worth 15. And you get to play the role of a judge, and you give a judgment for a plaintiff or against a plaintiff, and you give brief reasons for your judgment after you're given a fact pattern. All right, then we go on. The next question was, Griselda Reed, loans officer of the National Grab and Gouge Bank, grants a loan to Bernard Belcher's International Brewing Corporation. The far and near, we make and ship beer here and there, everywhere, Corp. I had to stay up really late with a glass of milk and a peanut butter and honey sandwich to come up with that name. And the bank wants the signature lines done correctly so that the parties are bound to the contract. So the next page shows the name of the corporation per authorized signatory, and another line with Belcher and a seal. Why? Okay, then we get into it. What does the per mean? Per means on behalf of, okay? It has a legal meaning, and that means that Bernard Belcher is signing on behalf of the corporation. Okay. Authorized signatory is the world according to Peter Holden. Put that on the exam if it's there. It's amazing how many students say, oh, that also means on behalf of. No. What it means is I'm saying take an extra step to make sure that the judge can't say, oh, wait, no, you spelled per wrong, so you're personally liable. Because if you're an authorized signatory for somebody, it's not you. It must be somebody else, and that something else is the corporation. Why does he have to sign twice? Well, he signs once for the corporation, and then the bank wants a personal guarantee. Okay? They will. All right? And then the last thing, why is the seal necessary? Seals are very important. Spend a lot of time looking at pages 50 to 57 of your lecture materials on seals. They're used often in business, okay, and people should really know their liabilities. The seal is necessary because Bernard Belcher is not getting any consideration out of this contract. Oh yes, he's getting money to his corporation. His corporation is a separate legal entity. He's not getting any consideration. His corporation is getting consideration. So if he signs without the seal, it's invalid. Even if the line says bracket seal, end of brackets, oh, and he must have meant to sign under seal because that's what the document says. No, the courts say the seal has to be affixed. Bracket seal, end of brackets is just a formality saying the seal is to be affixed there. So if you don't affix it, you don't have them. Okay? Question 3. English courts enforced one tort of trespass, and then over time, trespass became more sophisticated and broken down. So trespass to property was broken down into trespass to real property, which is just called trespass. Trespass to personal property, which is called conversion. Trespass to personal property. Oh, look. Unfortunately, the beer mug is empty. I just had soda water in there. But anyway, if somebody steals my mug, oh, I'll have them charged with theft. Yes, but that doesn't help you because the government charges them and puts them in jail, but that doesn't get your mug back. What you have to do is sue them for conversion, okay? And then it goes to trespass to the person, which is broken down into 3 categories. Assault, which is attempting to hit someone. So if I swing and miss, it is not a battery, it is an assault, okay? But if I swing and get you, then it's battery. The merest I consented to intentional touching of another. The third one is false imprisonment, taken and put in jail or held against your will. Okay, intentional unlawful confinement. Okay, question number 4. In order to win a claim for negligence, the plaintiff must establish that the defendant owed him a duty of care, breached that duty of care, and caused injury. Okay. There are a number of defenses available to defendant against a claim of negligence. There's actually, I think, 6 of them, and I'm going to be hard-pressed to remember them now because my head's so fuzzy. But there's criminal, see, there's contributory negligence, there's extirpi causa non orteractio, which means if I commit a crime, I'm not going to be able to sue you on the matter. There's waivers of liability. There's the volunti non fit injuria defense, which means in a situation where I take part in a zip line, I know the risks, I get injured, the courts say, hey, you knew it was risky, you accept the risk of loss. And there's a couple of others. They're in the material. You can look them up yourself, because I only asked you to put down 2 here. All right, the concept of a corporation is a separate entity from its owners. Answer these questions. The following questions make reference to sections of the appropriate statutes to explain how this can be done. They're talking about the limited liability. Section 30 of the BC Business Corporations Act. And oh my gosh, how could you ever remember all this sort of stuff for the exam? It's in your lecture guide material. The relevant sections of the Corporations Act are in there. You just open it up and look, okay? But don't wait until the exam and say, oh, I think now might be a good time for me to figure out what's in the BC Business Corporations Act. It might be a good idea to familiarize yourself with it ahead of time. Section 30 says the corporation is a separate legal entity. Section 87 says the shareholders are not responsible for the debts and obligations of the corporation. That's great. Shareholders are protected. What about directors and officers? Agency law. Okay? You're acting as an agent on behalf of the corporation, ergo you're not personally liable. When you sign a document per the corporation, you are acting as an agent. That is why you cannot be sued. Well, you can be sued. Everybody can be sued anywhere, anytime for anything, but you will not be sued successfully. The law creates the fiction of a corporate veil. One judge figured out that protection between the shareholders, directors, and officers in the corporation should be called something. So he called it a corporate veil in about 1886 or something like that, and the term stuck, okay? In sharp contrast to the limited liability of a corporation, sole proprietors face unlimited liability. There's no distinction between them and their business and their personal assets, okay? And partnerships, worse, okay? You're jointly liable for the debts and obligations, and you're jointly and severally liable for the torts. Okay, furtive negligence has expanded over the years since the remedy was created in 1714. No, that's a mistake. It was 1725, I think. But anyway, how have they expanded? Product liability, duty to warn, negligent misrepresentation, negligent omission, and then also the concept of duty of care was incorporated into the Authorized Liability Act. Okay. All right. Then question number 7 is getting your estate in order. What do you need? Well, you need a last will and testament. It speaks from the date of death. Till then, you can throw it out, destroy it, change it, whatever you want. But it only becomes valid when you die, and says who gets your assets. Power of attorney for your business, okay, because somebody that should run your business because you're now out of the picture and you want the business to be sold as an ongoing concern rather than for the value of the assets. Power of attorney for your personal matters. This might be the same person, both of those, but it's unlikely, okay. For example, my wife has my power of attorney to do banking, but she certainly couldn't run my law practice. I mean, I'm pretty sure she thinks she can, but she can't, okay. So I'd have another lawyer, his name happens to be Vincent Santa Croce. He would get to run my practice based on a power of attorney. My wife has the power of attorney to do my finances and things like that. There's a representation agreement. I authorize my wife to make medical decisions for me if I can't do that. Then I have a comfort letter. It lists off where I keep things, okay. You know, I keep that silver dollar from 1842 in my lower drawer of my bureau. Don't come looking for it. I'm only kidding. But you put it in a comfort letter. It's not a legal document, but it does help your representative in your estate. Okay, your boss sends you a memorandum providing you with instructions to give a return memo. Oh, don't worry about this one. Won't be on the exam. Haven't done that this year. After the memo assignment in class, I talked about if your boss says it's confidential, you mark it confidential. Even if you think it's not confidential, your boss will be irritated. He signs it, you sign it. Think about what your boss wants, okay? I think that's one of the things where some of the memos, one really, really good memo could have been that much better if after the memo information, the person had thought about what will argue had to do with that information and then gave will argue some guidance. Sort of things like that, but you don't have to worry about that one. It's not going to be on the exam this year. The next one will not be on the exam. It said, list and briefly explain 5 important concepts you learned during the year. And I said, if you decide to put down elements of a binding contract, don't list 5 of the 6. Because elements of a binding contract is one concept. And I got offer, acceptance, consideration, intention, legality. I'm going, didn't I just say you couldn't do that? Anyway, enough said about that. Now we get into the problem. And let me see. This year, in Part B, you have that Part B question 1 worth 15 marks, and then you only have to answer 3 of the remaining questions for 5 marks each, and that gives you the 30 marks. Okay. So, and I've given you 2 from 7, 5 choices, so you only have to do 3 out of 5. So you should be able to find 5 to do. Part C, last year it was fill in the blanks because, again, this was a closed book exam and it was 1 hour and 30 minutes. How can you do that exam in 1 hour and 30 minutes? Anyway, this year you're going to have 3 hours, all right, and it's going to be open book, and so I expect better answers. What I'm going to do is give you a scenario where there are torts and contract issues and maybe even, well, yeah, that's it. And as I said in the video on, or the material that I sent you on the tort problem, the best way to do it is start reading through the problem, and when you see an issue, or in English, an issue, and you would say, number 1, assault. Bob hit Frank, okay? And then on the right-hand side, you put, oh, pardon me, assault. I was wrong. Bob tried to hit Frank, okay? And then on the right-hand, you say apprehension of imminent harmful or distasteful contact. Well, you can write down in there, the 2 of them met in a bar and they had some drinks and then they got into an argument and then things got a little heated and then Bob took a swing and attempted to hit Frank. You know, write a huge paragraph if you want. It doesn't matter. I've got a good marking guide. I can wade through all that. The problem is you don't have a lot of time. You can't waste time. Assault. Bob attempted to hit Frank. That's all you have to say. Okay? Then I know that you saw it. And then on the right-hand side, you say apprehension of imminent harmful or distasteful contact, or an attempt to hit. Okay? And and then you get the 1 mark for the assault, and you get 1 mark for the principal. But if you write it out there, like I mentioned the first time, you only get 1 mark because you didn't give me the principal. Okay, so split your page in half. Write your issues down here, write your principles down there. Because if you start listing your issues and you go, I got 27 issues, and you go, wait, there's nothing over here, then obviously that what that means is you're not giving the principles as well. Okay? Okay. That being said, let's look at what was on here last year. It was regarding the possibility of Benton Counter acquiring the patent rights to something called the Tri-Box. All right. Okay. Let's see what. And right at the bottom of the first page, Benton Counter says, however, I want to know whether Tri-Box Manufacturing should be a division of PPP or should I structure the business arrangements some other way? And then Argue thought for the moment and said, well, PPP is an extreme sport business with a high risk, and so we structured it as a big problem here, right? No, it's PPP Inc., so it's a corporation. So that there is an imaginary barrier of protection which the courts call, hey, we've done this before if you answered that question, it's a corporate veil. That prevents liability for the shareholders, directors, and officers. In a sole proprietorship, you have unlimited liability, and in a partnership, you have joint liability and joint and several liability. I would recommend incorporating another company to handle Tri-Box business. That way, if a catastrophic event causes the demise of PPP Inc., it will not affect the Tri-Box. And if there is some patent problem, the Tri-Box will not affect PPP. Okay, I understand that, said Counter, but if I own all the shares in both companies, am I a director and officer of both? And if so, what protects me? Section 30, okay, the corporation is a separate legal entity. Section 87, shareholders are not responsible. And then that protects you as a shareholder, Benton, but what we have to do now is protect you as a director and officer, and that's the agency law. All right. A little bit farther down, Argue scanned the information. Counter said, Boxer lives in the USA and his manufacturing plant is in Mexico. Does that complicate things? Counter asks. Not really. It makes it an international contract, which is defined as a contract involving parties from different legal jurisdictions. Okay, this person put down international law. Oh well, they got a pretty good mark. With more than one jurisdiction involved, there's a potential for conflicts of laws because Canada and the U.S. are common law and Mexico is civil law. Furthermore, all these countries are signatories to the North American Free Trade Agreement. Yes, no. Okay, it's the USMCA now. Okay. Then we got into the 6 binding elements of a contract. Again. So we'll make sure that those are present. We'll deal with the problem that they are all signatories by putting in a clause. Execution and counterparts. Oh, okay. Works for me. Then we need a clause to choose the law or jurisdiction or whatever. The next issue is a clause to deal with the fact that the laws are not the same. That means you exclude conflicts of laws. We want to steer clear of litigation, so we will include a, this person put in boilerplate clause. Oh well, a med-arb clause, okay. NAFTA is still in effect, despite the efforts of President Donald Trump. So we can use Article 2022, and you can go to CAMPCA, okay. So you designate arbitration under CAMPCA, but that's old, okay, it's now the USMCA, but Article 2022 is still there. Because Mexico is involved, we need to insert the Fair Negotiation Clause. Okay. Argue thought for a while longer and then said, Boxer can sign for himself and his company, but he's in the U.S. and you're here. Put in a execution counterpart clause. Ooh, that means one of the earlier ones, which this person got wrong. I thought it was execution and counterparts, but I don't know what it could be. Let's see. No, I can't even find it. All right. So we will, this is the previous page. So we will make sure that those are present, the binding elements of a contract. We'll deal with the problem that they are all signatories by putting a clause into something or other. so it won't be on this year. All right. And he counter asks how the execution and counterpart clause works. And then there's signature lines. There will be signature lines. I have just marked my quizzes for my BADM 107 students, and I could shoot 80% of them because I told them signature lines would be on there. And I gave them examples, and they didn't even try to do it. Signature lines. How does the corporation sign? Tri-Box Manufacturing Inc. Per. A line. Underneath the line, Authorized Signatory. Okay, and then if there's another line, there'd be a seal beside it, because what we want is to get Bernard Boxer signing a personal guarantee, all right? A sole proprietor, how's he sign? Oh, some magic? No, a line, for crying out loud, his name underneath, and he signs there. How does a partnership, or a partner in a partnership, sign? A line underneath her name, she signs, bingo, that's it. But a corporation is a separate legal entity, doesn't have any arms, so it cannot sign. So somebody has to sign for it, and there comes the agency protection, right? As long as you put per there, an authorized signatory. But the courts don't like that. They go, hey, you're hiding behind the corporate veil. If your corporation goes down, you leave the other person hanging, and you walk away with your house and your car and your cottage and your yacht. No, we want you to be liable. So the only way you can stop the courts from holding you liable is make sure you act as an agent. Per authorized signatory. Then the judge will say, well, I don't like it, but the law is pretty clear. Okay? All right. Argue replied, corporations do not have to sign under seal, and Boxer's signature does not need one, because he is giving and receiving consideration. Okay? If there's no consideration going both ways, if goods and services and or cash or whatever isn't going both ways, then it's a gratuitous promise and it's not binding. Okay, these clauses, along with the entire agreement clause and the inurement clause, are what we call boilerplate. Counter gave Argue a retainer and told him to proceed with drafting the agreement. A month later, Counter was back in Argue's office. He explained that he was not concerned with tortious liability, such as liability of trespass, etc., but he was concerned about negligence and wanted to minimize risk. Argue explained that the concept of liability for negligence had expanded over the years. This person really didn't do well. Product liability. We've already done that in a question. Yeah, but that's because there's so few questions. They've got to be repeated to a large extent. Product liability, duty to warn, negligent misrepresentation, negligent omission, occupier's liability. But if that was on this year, I won't say list. I'll say list and briefly explain. Okay? What's good of getting you to list? Oh, look, here's a list. Okay? But if you have to explain it, then I have a better idea that you might know what it's about. Okay? Two of those specifically applied to peak performance pontoons, but the use of a waiver and buying insurance shifted the risk away from the company. But he should consider using, here's one for the personal flotation device people that did that memo. Warning labels. If you have a product, okay, here's the difference. A product that is negligently manufactured and hurts someone allows that injured party to sue for product liability, the negligent manufacture of goods. If I have a computer and it won't work, I cannot sue the Apple Corporation because they'd kill me, but no. I can't sue the Apple Corporation because that's just a breach of contract. Why isn't it product liability? Because I was not injured. If I open up my computer and it blows up my face and I'm injured, then I can sue for product liability. However, they make it perfectly safe. All right? But one of the problems is, in one of their editions, is that the lid snaps closed, and if your finger's there, you can get caught. Okay? So they just put a warning label on there. Before closing the lid of your computer, please ensure that your fingers are no longer on the pad, right? And that's not the case, but I'm just using it as an example. All right. Argue replied, that's okay. Good idea, Will. I just bought a bigger house with the wife and the kids, and I hate to lose it. Argue replied, that's unlikely. If one of your employees negligently manufactures some skis, there is a successful lawsuit against PPP Inc., the company will be vicariously liable for the torts the employees committed during the course of employment. But hey, you, Benton, you won't have any liability. That's because a corporation is a separate legal entity and the employee works for the corporation. He does not, or she does not work for Benton Counter. That is, of course, as long as you did your, this person puts in corporation, did your due diligence. There is a due diligence defense, okay? If I hire an employee and it's like Gronk, a throwback to 50,000 years ago, and totally incompetent, but I can pay him $1 a day and he's happy. He makes a mistake. He's negligent. The company's vicariously liable, but I will also be liable. Why? Because I was negligent in my hiring, okay? So you have to do your due diligence. Hire properly, let people go properly, have good HR management policies. Coming back to work after COVID-19, you better have all sorts of policies and procedures in place. Make sure you've incorporated, make sure you got your insurance. These are all due diligence things that you should do. Okay, that's the good news, Will. But what if one of my customers buys the skis and then sells them and gives them to another less capable person and that person gets injured? Well, this is an extreme sport and potential dangers are well known, so the maximum valenti non fit injuria, or voluntary assumption of risk, applies to participants. What does that mean? I always throw in some Latin so I can charge my clients more. I used to use that line when I was dealing with my clients. I'd say, oh, well, the valenti defense. They'd say, what? I'd go, the valenti non fit injuria defense. And they'd go, what? And I'd go, that way I get to charge more. But I'm only kidding. All right. With a laugh, he explains what it means. Okay, one other matter before I go. A well-known water skiing champion, Phyllis Frumster, works for us, and we use her pictures in advertising. However, Rapid Racers, Inc. has put her picture on one of their brochures. Phyllis is not amused, but the owner of Rapid Racers says that the picture was her when she was winning her gold medal, so it must be in the public domain, meaning anyone can use it. Is that correct? No, Benton. The unauthorized use of someone's picture or likeness is a tort called misappropriation of personality. Okay? All right. You go to a hockey game and you want to get a picture of a crowd for some advertising. And you go, hey, look, there's Wayne Gretzky. Does anybody remember who he is? Okay, hey, look, there's, I can't think of any famous person. Oh, hey, look, there's Justin Trudeau. All right, let's get somebody really important. Hey, look, there's Peter Holt. And you zero in and you get a picture of the crowd to use in your advertising, and I'm prominently displayed. I probably get to sue you. Hey, but you're just part of the crowd. No, you took a picture of the crowd with me in there because you wanted to capitalize on my fame. Okay, now you know I'm kidding. Okay, let's go back to Justin Trudeau. Anyway, but if you just take a picture of a crowd, you're probably okay. All right. Okay. And that was it from last year. Now let me see if there's anything else I'm supposed to suggest. Page 11 of your election materials, the use of your lawyer's time. There's 9 bullets. One of the students asked me where that was because she couldn't find it in the lecture guide on eLearn. So that's where that is if you want to have a look at it. Pages 12 to 17 of the lecture materials is the statutory material. Just some important sections from the Business Corporations Act and a few important sections from the Partnership Act. And then pages 50 to 57 of the lecture material on the execution of documents under seal is important. Okay, I cannot think of anything else at this particular moment. I guess, but the only other thing is the midterm was worth 90 marks, but I convert that to 50, to whatever percent of the grade it is, right? And the final exam is worth 100 marks, but I convert it to whatever percent of the grade your midterm exam is worth. Okay, well, that's it, and I did manage to get through without my throat drying up too much. I will immediately upload this after I get it into a file format that YouTube will accept. And then if you have any questions, you can ask me and by email, and we'll go from there. About the only other thing is I'm supposed to give a common final on the midterm exam. It turns out that one of the students in the earlier section passed the exam to some people in the later session. I would like to avoid that. Okay, so what I'm going to do is I'm going to send out an email and ask you all if you can write on. Just let me grab my binder and make sure I get the date right, because I'm always getting them wrong. June 25th. Okay, from 2:30, 3:30, 4:35, 2:30 to 5:30 on June the 25th. Otherwise, I have to do 2 different exams, and if I do 2 different exams, everybody's going to be all liking, oh, theirs was easier than mine, and stuff like that. And I've got to do 2 exams. So I prefer not to do that. So hopefully we can do that as a common exam. Otherwise, the people in the later exam will just get better marks, or at least some of them. Okay, that's enough for now. Thank you very much, and good luck in the exam when it happens.